Lisa Decker, CEO and founder of Divorce Town USA and DivorceMoneyMatters.com, and welcome today to my show at the Divorce Way Café. I'm excited to have with me today Steve Worrall. Steve is a family law attorney and estate planning attorney here in Georgia, and today we're going to be talking about your divorce options. Yes, you do have them, and the pros and cons of each. So get ready for a fabulous show. And Steve, welcome to my call today.
Thank you, Lisa. Glad to join you.
I'm always happy to have you as a guest. You are so knowledgeable and you bring so much value. So listen up, folks. We're going to be talking about the ins and outs of the ways that you can go to get divorced and what you need to know in choosing your path. So those of you who are familiar with my Divorce Town Roadmap will know that I am an advocate of trying to stay on Peaceful Place and Savings Lane versus working through town and getting over to Bigger Bucks Boulevard and Duke It Out Drive. We want to try and keep you away from those options. And in order to do that, you need to know what your options are and the pros and cons of those. So Steve, you know, how do you feel about folks when they come in your door and they really have no understanding of where to start and they don't have an understanding of their financials? How do you guide them in getting started at that point?
Well, my approach is very educational, as I believe yours is as well. I offer them a lot of different options and help them choose the best means and methods that are suited for their needs.
Right, and you know, everyone will have different needs, and so in making those choices, it's important to consult with an attorney up front who can share this information with you and then determine the best course for you to go. Now, as a divorce financial planner, I will tell you that walking in the door, having an understanding of your financials and being able to show that to your attorney is going to be very helpful to not only you, but to your attorney as well. So looking at getting your financial ducks in a row is always a good start if you're planning on getting divorced, pre-divorce financial planning. But once you're ready to make the move, let's start with mediation, Steve. That's it. Okay. You know, on the left side of town, in that peaceful place, more civilized, respectful divorces. Many times folks will come to me, they don't understand what mediation is, they don't understand a self-directed mediation versus a court-mandated mediation, so maybe you could tell us a little bit of that.
Sure. A lot of times, of course, let's talk about court-directed mediation first. Almost all the courts in the state of Georgia now have some sort of alternate dispute resolution program that usually takes the form of court-ordered mediation. When that is ordered to occur may vary depending on which county you're in. Some courts require you to mediate at a very early stage. Some will only let you, or some will require you to do it before you can have a final trial of the case. So the ones that do it early on may require you to do it even before you can have a temporary hearing and obtain temporary relief from a judge. The others will allow you to get that sort of relief, but then not let you go to the trial, the final trial of the case, until you've gone through mediation. With private mediation, there are a number of different people in town that are, of course, all the trained mediators that are on the court programs. Many of them will also do private mediations, and that is simply a method of the two parties sitting down either with attorneys or without attorneys. You can have attorney involvement or not. Obviously, without attorney involvement, you can lower those costs, but you won't have the benefit of having legal advice during that process as well. So that's one consideration. But basically, the various options amount to the number of people at the table. The two parties can sit down at their kitchen table. They can sit down privately with a mediator with 3 people at the table. They can have the two attorneys and the two parties sit down together in a 4-way settlement conference, or they can have all of those 4 people involved with the mediator at the table and working through these issues. And those are the different levels of involvement.
Very good. And I will add that they can also bring in a divorce financial planner as a neutral party, or they can each bring their own financial advisor to mediation if they are working, you know, in a different manner. So it may be 4, it may be 5, it may be 6, depending on how they want to go through that process. But it is generally a more respectful peaceful way to go about it. And, you know, a lot of people are afraid of mediation. They don't understand what's going to happen there. They don't want to sit in the same room with their spouse. So can you give them a little flavor of what happens at mediation?
Sure. Typically, when you have a mediation, either with attorneys present or without, the mediator will meet with both parties together at the very beginning, typically, so that they get some idea of what the case is about, what the issues are. But then they will typically break off into separate sections that they call caucuses. And you can think of it like the shuttle diplomacy that Henry Kissinger engaged in with China back in the 70s. The mediator will shuttle back and forth between the parties in different rooms, or he'll shuttle the parties in and out of the room that he or she is sitting in, and meet with each side separately to get the information and to discuss offers and counteroffers as the process goes forward. So that's typically the limited amount of time that the parties have to spend together in a mediation. Generally, then,
okay.
if they do come to an agreement, they will come back together to review the agreement in a memo form that the mediator has prepared to make sure that all the points have been covered and that they've been covered in the way that both parties believe that they have agreed upon. And then if they are in agreement with that memorandum, the mediator will typically have them both sign off on that mediated memorandum. They also, at the beginning, will also sign off on a document that reflects the guidelines of mediation. Most mediators will go through a set of guidelines about the mediation process in which they're encouraging the parties to leave fault and blame aside as much as possible. They'll talk about the duty of disclosure of all of the assets, because if you don't do that, it's certainly possible that the mediated agreement could fall apart because of misrepresentation or fraudulent non-representation of certain assets. So you want to make sure that all those things are disclosed. The mediators will also tell you that they are mandatory reporters of child abuse, so everything else is confidential in that process, but if there's an issue of child abuse that's not previously been reported, they have a duty to report that. So they would let everybody know that right up front.
Very good. Now, if you are working in a self-directed mediation with a private mediator, the point that you made about disclosure, full disclosure, my understanding that a mediator cannot compel you to produce documents, but if you're working with attorneys, that has already been done. Is that a differentiating factor there?
Not always has it been done. It depends on how early in the process you're mediating. Most attorneys, though, that are involved in mediation are going to want at least the bare minimum disclosure through the form of a financial affidavit that's been prepared and sworn to by the party that's preparing it. So that you have something under oath that you could later go back and tell a judge that, well, we found out that there was a business worth $5 million that wasn't disclosed on this affidavit. So that's a good reason to set the agreement aside in that situation because of that lack of disclosure. As far as the private mediation situation, no, the mediator cannot compel it in any of those events, but it's just part of the guidelines to say that if you don't disclose, the mediator is just letting you know that if you don't disclose all of your assets and those assets are later discovered, then this whole process could be undone by that failure to disclose.
A measure of protection there. And I think
Absolutely.
that in a private mediation, there has to be some level of trust between the spouses.
Correct.
But either way, mediation is a fabulous tool to get divorced without having to go through a long, drawn-out, contentious, expensive battle. So many people don't understand what mediation is about. They don't take advantage of the day, you know, especially if there is a lot of emotional charge. They go in thinking, my spouse is not going to agree to anything. We're only doing this because the judge has ordered me to. And they're really missing out on a fabulous opportunity to, you know, come to their own terms as best as possible and get the divorce settled. So if they choose not to go through self-directed mediation or they're not successful at court-mandated mediation, we might be looking at some other options. And, you know, another process to get through divorce is collaborative divorce approach.
Right.
And I know both you and I are collaboratively trained. Speak to the audience here about collaboration in a collaborative divorce setting, what that's all about, and some of the pros and cons of that.
Well, what I like about collaborative litigation, or excuse me, collaborative practice, is it is a non-litigation approach. the parties agree up front to not go to court unless and until they reach an agreement. One of the other, they will sign a participation agreement with the two lawyers that they have hired to represent them in this process that says the lawyers are not going to represent them in a litigation. So there's a bit of a carrot and stick approach there. The carrot is we're going to resolve this without someone else in a black robe telling you what to do. This is going to be self-directed, self-determined. The parties are going to resolve the issues themselves with the assistance of the attorneys, but it also involves a multidisciplinary team where that team is appropriate. So you may see other people involved, such as a financial neutral, such as a child specialist who is being the voice of the children, and such as a divorce coach. Sometimes we have two coaches. Sometimes we will have one coach acting more as a facilitator. And I've been involved with a lot of cases where we employ some of these same tools, even in a litigation context. But a true collaborative case does require a participation agreement to be signed, a contract between the parties and the lawyers, that the lawyers are not going to be involved in the process if it breaks down. Both parties are free to opt out of the process at any time, but in so doing, they lose those attorneys that they've already paid for. They lose the other professionals that they've already paid for. So there is that downside risk to them of jumping out of the process. The other highlight and hallmark of a collaborative process is that full disclosure that we were talking about before. You don't have the court process to compel the disclosure of information in this process. You're contractually agreeing to provide whatever is needed, whether the other side asks for it or not. If it's important to know that you have a business or that you have a bank account or stock accounts that are to be divided in this case, we don't have to have the other party ask for it. You have a duty to disclose it right up front. And so we use a series of meetings between the different parties to deal with the different issues in the case. So we may have the divorce coaches or the facilitator working on the parenting plan for parents that have minor children and have to deal with the custody and the visitation schedules. They will also deal with who makes the decisions about the children, those final decision areas of health, education, religion, and extracurricular activity. And then the financial neutral will take the financial pieces of the puzzle, the incomes of the parties, the assets of the parties, the expenses of the parties, and the debts of the parties, and help the parties work through those pieces by determining the issues of child support and alimony and division of property and debt. So it's a good process to avoid litigation. It keeps the parties in control, but it is a little bit more expensive than private mediation or even court-ordered mediation. Because you have the different people involved. But not every case has to have all of those people involved.
Right. And, you know, just to be clear, that all of the advisors would sign the same contracts. So basically, correct, everyone is agreeing that you're going to work it through to resolution, or no one is going to be working together again with this particular couple. And so, you know, everybody is really trying hard to get the resolution here. And one of the other pieces of that, oh my goodness, I've forgotten my question here. It'll come back to me.
All right.
So we'll move on, and I'll remember that in a moment.
Okay.
So it differs from a cooperative approach, mm-hmm, in that cooperative, you can have all the same team members, you can, mm-hmm, have the same ideology, if you will, that we're all going to cooperate and try to get to resolution, but you don't give up, mm-hmm, the right to litigate. Is that correct?
That's correct. That's correct. I mean, cooperative is not actually even a term of art like collaborative is. I think collaborative is actually trademarked by the International Association of Collaborative Professionals. So it does define what that process looks like. Cooperative is a little bit more ad hoc as far as what the parties want it to be. But the idea is, yes, we have two teams that are working together and using perhaps even some of the tools of the collaborative process for the purposes of helping this family through the divorce and getting a result that they have controlled and that they have determined for themselves, as opposed to letting a judge decide. But you don't have the opting out, the provisions of the participation agreement that require the parties to lose those attorneys or those other professionals. So, that for example,
I do remember now is the fact that You've got to be committed to the process, to the team, and really understanding that everyone wants to resolve it without having to spend the money to go to court. And we're going to talk about that in a minute. But it is a commitment level with collaborative versus cooperative, which has the same commitment. Everybody wants to get their case resolved, but you are able to hold over someone's head, if you will, that, you know, if we can't resolve this, we're going to take it to the judge.
Right.
Yeah.
At the end of a collaborative meeting, you often you may have a situation when the parties are just as angry as they might be in a litigation process, but they're committed to the process, and so at the end of the meeting, they say, instead of saying, "I'll see you in court," they'll say, "I'll see you at the next meeting."
And you know, making that commitment up front is sometimes all it takes to really follow through with it, and you know, can save people a lot of angst, a lot of money in going to court. So we've talked about the mediated process, and we've talked about collaborative, and we've talked about cooperative, but for some folks, you know, they're really not going to have a spouse that's going to work in that vein with them. I mean, they're being locked out of their home, their bank accounts are being shut down, you know, things are not going well at all, and their only means of protecting themselves is, you know, taking that traditional litigated route and getting a judge involved. So let's talk about what that looks like and give people a sense of that.
Okay. That process starts out with the filing of a complaint for divorce. You have to have a reason for asking for a divorce in Georgia, and there are 13 statutory grounds. One of them is the most commonly used. That's the no-fault ground. The other grounds are fault-based. They require the proof of a specific type of fault, like adultery or cruel treatment. But the no-fault ground just simply requires that the evidence be presented that this person doesn't want to be married to the other person anymore. You know, they say it takes two to stay married, but it only takes one to get divorced in Georgia. And if the judge hears the evidence that this person, the wife, for example, doesn't want to be married to the husband, then the judge has no choice but to grant the divorce and to deal with the other issues related to the divorce, such as custody of the children or child support or alimony or division of property. The complaint has to be served on the other side, either in the form of a sheriff handing those papers to him or her, or a private process server, or the party can sign an acknowledgement of service, which is essentially a receipt saying, I acknowledge that I've received these papers. You don't have to have the sheriff serve me. That document is filed with the court and substitutes for having the sheriff file an entry of service form with the court. After that is filed, it's very typical that you would ask for a temporary hearing, something to deal with the issues of what are we going to do now from now until the final case, this case is finally resolved, whether that's as a result of a trial or us coming to an agreement. So things like who's going to stay in the house, who's going to have primary custody of the children on a short term, on this temporary basis, who's going to pay what in the terms of child support and or alimony, who's going to pay what bills, and those sorts of things, who's going to use the cars. So those are issues that will be decided at a temporary hearing. There's also the issue of discovery. We talked about disclosing of assets. This is the formal process to request disclosure of financial information and even conduct-based information, and it takes the form of either a notice to produce and request for production of documents. It's essentially like a subpoena that you're serving on the other side, asking them to produce documents within a specific period of time, usually 30 days, although if it's served with a complaint, it's 45 days. Or written questions called interrogatories that have to be answered under oath. Those would include things like, well, tell me anybody that has any information about this case that might possibly be witnesses, and what you think they know, as well as disclosing other financial information or other information about conduct. And finally, the other primary method of discovery is a deposition, where one side will serve a notice of deposition on the other party, telling them to come to the other lawyer's office and sit there and be questioned under oath in front of a court reporter. And both parties will generally do that if one party does. So those are the typical forms of discovery in the case, in a litigated case.
Okay, so it gets more complex, there's more layers, there's more things involved, there's more cost, there's more time. And so what we're hoping is that folks will look at all of their options and determine, you know, what the best path for them is. If none of these paths work, and they do go before a judge. Let's talk about that. I know that, judges are assigned randomly, so you really don't know which judge you'll end up in front of, and you don't know what your outcome will be. You're asking a stranger to make decisions regarding your family and your finances, and so it is a risk going to court. So we want folks to know the pros and cons of that as well.
Well, most judges will start off a calendar call for a family law set of cases by telling the people, look, I don't know you, I don't know your family. If you're thinking that I can make a decision that's going to resolve the issues between you for a lengthy marriage and children of certain ages better than you can resolve on your own, you're crazy. But I'm here to do it. That's my job, and I'm ready to do it if I need to. But you truly are rolling the dice, because this person has no clue. There may be certain biases that this judge may have, just normal biases that any person may have. That this judge may be more favorable to men. This judge may be more favorable to women over historical time frame. But you really don't know the outcome until the judge gives you the ruling at the end of the case. And so you truly are taking a very big risk when you do that.
And it's a lot of money for your attorney to prepare. You have a lot of preparation to do. There are expert witnesses you need to bring in. And so, share with folks about that so they do get an understanding. Because a lot of people come to me and say, I just want my day in court. I just want someone to hear what my spouse has been doing, thinking that validation will help them heal, help them feel validated that someone's listening. But in the end, what do they really get for that, and what is the cost for them to get there?
Well, the cost can vary substantially. I came across an interesting chart the other day, and I'm trying to pull that up right now, but while I'm doing that, I'll talk with you about it. Basically, a divorce can cost anything from just a couple $1,000s to resolve an uncontested case up to hundreds of thousands of dollars. There was one instance I heard about where one party paid over $162,000 to get a divorce. Is that good money spent in her case? Who knows? But it certainly may have been very necessary because the other side just wouldn't settle. But that is certainly something that you need to understand going in, that cases can get very expensive. Both lawyers are spending money on an hourly basis, your money on an hourly basis, for them and for their team members for all the work that's being done on that case. I'm looking at a chart right now on win-windivorce.com. It's an admittedly unscientific sampling of attorneys' fees, and this also gives you some idea of how long cases can last. I mean, these range on this chart from anywhere as short as 572 days from filing to disposition, and a total of attorney's fees of $38,000 to one that took 1,535 days. That's close to 5 years.
Yeah.
In a modification case where the attorney's fees were staggering. Another one that was almost 3 years, 1,072 days from filing to disposition. The attorney's fees, the expert fees of both parties were $231,000. That's the case where the wife paid her own fees of $163,000 and the husband paid $68,000. That was a case in Cobb Superior Court. So it's just staggering the amount of money that can be spent in a case where that money that could otherwise be going to pay for the children's college, pay for their weddings, to just maintain the lifestyle. I can't even imagine this family coming out of pocket in this case of close to $250,000 between the two attorneys. It just doesn't make any sense in most cases. Like I said, I don't know the facts of that case. It may be absolutely been necessary, but the fact that the wife had to pay her own fees and the husband had to pay his fees tells me that the judge didn't think it was important enough to award attorney's fees, because that's often done as a method of allocating responsibility. The judge will deal with the issue of attorney's fees typically at the end of the case. And at that point, they want to know, after they've made their decision, what were the settlement positions of the parties throughout the history of this litigation, to see if the parties could have avoided this case by settling for an offer that was better than what the court did in this case. And if the court feels that for example, if the wife made an offer to the husband 3 months into the case, and this case lasted a year, that was better from the husband's standpoint than what the judge did for the husband in the case, then the court can say those last 9 months are really your fault, Mr. Husband, and I'm going to make you pay her attorney's fees for that period of time that she incurred, because it's your fault that we're here today and that you didn't settle this case.
So that's something else to be aware of. Pick your battles wisely, right? And these are the things that people just really don't understand going in, how the path can twist and turn and where you can end up. And I know a lot of cases that I've seen, those initial offers, a lot of times that's what they end up coming back around to after all that time and money. So
yes.
Really having some common sense and understanding the financials, I think, also helps people go a long way towards becoming settlement-minded, because a lot of times clients have unrealistic expectations. They may believe there's more money than there is. They may want to be kept in a certain manner, and there's not enough money to support 2 households. So when you have a 3-legged stool approach that we talk about in the world of divorce, which is getting the emotional support so you can make sound decisions. You're getting emotional support either through a therapist or a support group of some nature. When you have the legal support so that you understand the legal ramifications of your choices and what your options are. And you add the financial support so that you have someone who is looking at it with a keen eye and able to explain it to you in such a way that you can't dispute it in black and white. I think people get a much better outcome. So that team approach, no matter which path you take, even if you're doing self-directed mediation that we talked about in the beginning, you still should have legal advisors, attorneys that you can consult with along the way, so that you're getting the best of all worlds, and then you can make the best choices in this process. So we hope through our show today that we've given you some information to ponder if you're considering divorce, so that you pick the right path for you. And we do hope that you are able to stay on Peaceful Place and Savings Lane and stay away from Bigger Bucks Boulevard and Duke It Out Drive. In the end, there are no winners. So, Steve, thank you so much for being my guest today, and please let the viewers know how they can contact you, and also a little bit about your estate planning practice, because it's not just getting you through the divorce. We want to make sure that you're making wise choices about things afterwards, so you don't end up with problems on the other side. And Steve is a masterful estate planning attorney as well.
Thank you for that, Lisa. I appreciate that. Folks can reach me at the Manili firm. That's Manely firm in our Marietta office. We are located throughout the state of Georgia in 6 offices: Atlanta, Marietta, Canton, Gainesville, Lawrenceville, and Savannah. Our website is www.allfamilylaw.com. That's allfamilylaw.com. You can reach me by email at steve@allfamilylaw.com. I also have my former practice website, georgiafamilylaw.com, with a lot of information about family law and estate planning topics there. Our phone number in the Marietta office is 770-421-0808. I have moved my practice primarily into estate planning now. I'm here at the Manili firm creating the probate and estate planning department for the firm and servicing our clients throughout the state of Georgia in those fields. It is very important when you're going through a divorce, or you're about to go through a divorce, or after you finish a divorce, to look at the issues of estate planning at those various times. There are certain things you can do and certain things you can't do. During the course of the litigation, once a divorce case is filed until it's over, you're pretty much restricted by the issuance of a standing order in the case that says you can't make changes to your financial circumstances, and a lot of people would interpret that to include estate planning as well. You certainly, before a divorce is filed, can change your will. After divorce is done, you can change your will. You can change things, I believe, during the course of the divorce, dealing with your health care issues. Post-divorce, if you've had a health care directive signed before your divorce, your spouse is treated as if they don't exist anymore, your former spouse, if they were named as your health care agent. A lot of people going through the divorce, though, they don't want those people being the potential person to pull the plug on them or make the decision about pulling the plug. So it's very important to, before a divorce is filed, to make those changes if necessary. With regard to estate planning and your will and divorce, if you had a will before you were divorced, it used to be invalidated by a marriage or divorce. Today it is now, if you get divorced, your spouse is treated as if they predeceased you if you don't get around to doing a new divorce, a new will after the divorce. But it's still a very good idea to take in consideration that major life change and use that as an opportunity to create a new plan for yourself. So we do prepare wills, living trusts for clients that feel that those are appropriate for them, healthcare directives, and financial power of attorneys. Those are all very important documents. Every adult should have at least the will, the financial power of attorney, and the healthcare directive. Anybody over age 18 needs to have those things in place. And so I would encourage all of you to get those documents in place and to counsel with an estate planning attorney about those issues.
Absolutely important, very important, and remembering also to change those beneficiaries because you don't want ex-spouse to be inheriting things inadvertently. And these are the things
Correct.
that Steve, as an estate planning attorney, can help you with. So we want to make sure you're making wise decisions before, during, and after your divorce. And the Manelli firm is also another firm that is highly recognized and valued in our community. So reach out for those resources, folks. There's help out there for you. Don't try to go this alone. You need all the support you can get. And again, Steve, thank you so much for your time today. Always so much wisdom to bring to our audience, and I appreciate that. And give that website one more time.
It's www.allfamilylaw.com and www.georgiafamilylaw.com. Thank you, Lisa. I've appreciated this opportunity, and you are a great resource as well. We depend on you heavily in many of our divorce cases to help our clients get the financial information that they need and get their ducks in a row.
Thank you for that. I appreciate that. It's always a pleasure working with you. And I can be found at divorcemoneymatters.com. And don't forget to check out the resources at Divorcetown USA. Steve is one of our members there, and you can find all of the resources that you need to get you through this difficult, challenging time. All right, until next time, thank you so much, folks. Take care.
Thank you.